SwayamPrabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 22nd lecture, and the topic of today's presentation is protection against sexual exploitation and children human right. So, this lecture will emphasize on protection against sexual exploitation, POCSO, and children's human right. So, first of all, I would like to throw some light on rights of the child. Students, as you all might be knowing that Indian Constitution, being a supreme law of the land, has guaranteed certain rights as a fundamental rights to the children of this country. For example, children are also entitled to get all the freedoms, fundamental freedoms which adult can enjoy. Children are also entitled to be treated equally. They are entitled to get this equality right to equality, Article 14. They are also entitled to express their views, ideas, freedom of speech and expressions, right to education, that is basic rights which a child can avail, and child has a right to get education free of cost up to the age of 14 years. So, from 6 to 14 years old child, they are entitled to get education free of cost. If they belong to, if they are poor, they cannot afford school fee, then it is the duty, it is constitutional obligation of state to provide education free of cost to those children who are poor. So, for that purpose, you all might be aware that government parliament has enacted a special legislation in order to provide education free of cost, right to education as a fundamental right. Right to life, children are entitled to avail, they are also entitled to live with all human dignity, Article 21. Right to life is given as is provided as human right under Article 3 of UDHR. Right against inhuman treatment, they are entitled, children are entitled to be treated humanely, they are human being. So, this kind of protection is also available against, so for them children are entitled not to be discriminated, protection against discrimination, right to food as a fundamental right. You might be knowing about that incident which happened in Odisha, state of Odisha, where starvation death was reported. So, due to which Supreme Court intervened in the matter, and Supreme Court for the first time recognized, Supreme Court in the year of 2001 for the first time recognized that right to food as a fundamental right. Right to food is an essential component of life. So, no life can be preserved, protected unless starvation death is going on, unless people are died due to hunger. So, in that sense Supreme Court for the first time recognized that right to food is essential component of right to life. Without giving food to poor people, we cannot protect their right provided in the Constitution. So, for that purpose Supreme Court intervened in that area, right to food became fundamental right under Article 21 of the Indian Constitution. Right to education, as I have already highlighted. So, you look at your screen, I have just mentioned this Protection of Children from Sexual Offence Act 2000. This Act is to prevent children from sexual abuse. Effective remedy. In order to provide effective remedy, Parliament decided to enact special legislation for the betterment of children, and in order to protect their human rights, Parliament has enacted this special legislation. Now come to protection of children from sexual abuse. Under Indian Constitution, Article 21 talks about right to live with human dignity, right against trafficking, section Article 23 and 24. Protection of children, or you can say protection of rights of child under statutory provision. The Immoral Traffic Prevention Act 1956 is there. This is a special legislation. Second important legislation is Indian Penal Code 1860, kidnapping and abduction, kidnapping for prostitution, begging. All these things have been criminalized in Indian Penal Code 1860. Kidnapping is an offence, and kidnapping for the purpose of prostitution is also an offence. And we will try to understand role of Supreme Court in protection of rights of children from sexual abuse. So, let us discuss one by one. Article 23 of the Indian Constitution, which talks about right against trafficking, right against immoral trafficking, or Article 23 of the Indian Constitution, which also prohibits beggar and trafficking of child, where any child who is whose rights are violated, or any act of kidnapping or kidnapping of a child for prostitution or begging purposes, it would be an offence under section 366, 360 of the Indian Penal Code 1860, kidnapping for prostitution, that is offence. Article 24 of the Indian Constitution, which talks about prohibition of children in any hazardous industry. No child below the age of 14 years shall be employed in any industry or in any employment. So, in order to, you see, the purpose behind enacting this provision in the part 3rd of the Indian Constitution is to protect the rights and dignity of a child, that no child below age of 14 years shall be employed in any hazardous employment. So, you see, neither government employer nor private employer shall engage a child who is below 14 years. So, you see, these are certain constitutional provision where rights of the child are protected, or we can say that Indian Constitution has made clear cut provision about protection of the rights of child. But considering the gravity of this issue, Parliament in the year of 2012 has enacted a special legislation. The name of legislation is Protection of Children from Sexual Offence Act 2012. In brief, that act is referred as POCSO Act. Before I start that statute, before I explain essential feature of that statute, I would like to highlight the background of this special legislation. I would like to throw some light on judicial pronouncement which have been instrumental in passing this legislation, in making this law. So, I would like to highlight one case which you all might be aware. The name of case is Tukaram vs. State of Maharashtra, AIR 1978 Supreme Court. In Tukaram case, Tukaram vs. State of Maharashtra, AIR 1978 Supreme Court. This case is popularly known as Mathura rape case. What actually happened in this case, Mathura rape case, the facts of this case which I wants to elaborate. Who was victim in this case? A 16-year-old girl along with her brother, they went to the police station to give information to the police about an incident. But police, two constables, Tukaram and Atmaram, both were present at that police station, and they asked the brother of Mathura to wait outside the police lockup, and Tukaram along with his guilty partners, they committed rape against that girl. But after some time, when brother was waiting outside the police lockup, when his sister didn't come outside, then he tried to inquire. Then he found that his sister was not in, his sister was in bad position. She stated entire story to his brother, and then matter was brought, FIR was lodged against both constable. Matter was, trial begins, trial. Then you see what happened in that case. Trial court as well as high court convicted, found them guilty for committing rape, and they were convicted. So, in this case, Tukaram, he went in appeal before the Supreme Court, challenged the legality of that judgment and went in appeal. Supreme Court, on the basis of medical report, found them innocent, and they were acquitted by the Supreme Court. Supreme Court observed that in medical report, doctor had not mentioned any injury on the body of the victim. It appears that no injury or scratches were found on the body of victim of the rape. So, inference could be drawn that act was committed with the consent of the victim of crime. So, and in this way they were acquitted by the court. Then this matter was debated, and this matter, but Justice Krishna Iyer, who was also, who expressed his view in dissent, he said that, he observed that in such a situation, judiciary should not draw inference that a victim of crime, a victim of such offence is helpless in such a situation. In helpless situation, means judiciary should not draw inference that no hue and cry was made, neither scratches were found on the body of the victim of crime, since in such type of crime victims are in helpless condition. So, court judiciary should not draw inference that she should have made resistance, she should have objected, hue and cry should have been made by the victim of crime. Rather than this, apart from this, court should draw inference that act was not committed with the consent of the victim, and burden of proof should lie on the accused. Accused should prove before the court that act was not a consented act. So, Justice P. R. Krishna, he made a remark, he expressed his view, he expressed his minority opinion, and his minority opinion got recognition in Rafiq versus State of UP. Supreme Court itself recognized the minority opinion of Justice V. R. Krishna in Rafiq versus State of UP. The point is that in Mathura rape case, the minority opinion, minority view expressed by Justice V. R. Krishna got recognition in Rafiq versus State of UP case. Now, come to the second important case, that is Munna versus State of UP, that is also known as child abuse case. What happened in this case? a child who was suffering from, against whom an offence was committed, sodomy was committed, he made allegation before the competent authority that this kind of things are happening inside the jail of Kanpur. This case is also known as Kanpur jail case. So, that incident happened in Kanpur jail, and where a 16-year-old boy was victimized. Allegation was made by him, and when inquiry was conducted by a district judge of Kanpur, then he found all the allegations true. And now come to another important case where Supreme Court has issued. This is all about your protection of children from sexual abuse. Come to another aspect of POSCO Act. So, let us understand this Act, POSCO Act, in the light of statutory provision. As you all might be knowing that Article 15 Clause 3 and Article 21, these two important constitutional provisions are important to discuss at this point of time. Article 15 Clause 3, you all might be aware that nothing in this article shall prevent the state from making any special provision for women and children. Article 15 says that no discrimination shall be made on the ground of race, caste and sex. So, state is prohibited to make discrimination on the ground of race, caste, sex, religion. It is provided under Article 15 Clause 1. But in the same article, in the same provision, Article 15 Clause 3 gives liberty to the state to make special legislation for the betterment of women, for the betterment of children. So, under Article 15 Clause 3, Parliament or state legislature can make special legislation for the welfare of women and children. So, keeping all these things in mind, Parliament enacted special legislation. That name of that legislation is Protection of Children from Sexual Offence Act 2012, POSCO Act. Now, I would like to discuss salient feature of this act. Child below 18 years are covered under this act. Protection from sexual assault, sexual harassment, pornography, all these activities have been covered under this POSCO Act. In order to ensure speedy trial through a special court, every state government shall have POSCO court, meaning thereby there shall be separate court for what? For speedy disposal of the cases pertaining to child abuse. The name of that court is POSCO court. Minimum punishment is 7 years. If child is below 16 years, punishment is 20 years. So, you can see the gravity of, you can see the consequences of this act, where any wrong is committed which is covered under this act. If child is below 16 years, punishment, that wrongdoer may be awarded punishment which may extend up to 20 years, or otherwise minimum punishment is 7 years. Safeguards under POSCO Act. A victim of child sexual abuse can file a complaint at any time, irrespective of his her present age. So, you see, let us understand this. A child against whom the offence was committed before 4 or 5 years, even after 4 or 5 years, if that child makes an application to the magistrate, that application shall be accepted by the magistrate. Magistrate cannot deny, cannot refuse to accept that application merely on the ground of expiry of the period. So, you all might be knowing that section 468 CRPC, which talks about time limitation about cognizance of the offences. So, that provision would not be applicable to this POCSO Act. So, considering the gravity of issue, this liberty has been given to a child that irrespective of age of the child, he or she can make application regarding this offence whenever he or she desires. So, this is very important feature of this act. Now, come to this second important committee, Child Welfare Committee. This committee must be informed about child abuse within 24 hours. This Child Welfare Committee will appoint a support officer. What kind of support officer? For psycho-social well-being of child. This Child Welfare Committee shall appoint a support officer who can give advice to the child who is victim of such kind of offence. Psychotherapy or psychologist may also be provided to the doctor, so that the child who is victim can be kept out from that mental trauma which that victim is suffering. So, it is the duty of Child Welfare Committee under this act. Now, come to this slide, I have also highlighted the efficacy of this act, to what extent this act has been effective. You see, Supreme Court has held that a 38 years old woman with 6-year mental rape victim is also entitled to get compensation. Victim of this crime, they are entitled to get compensation from the wrongdoer. Mandatory reporting of child sexual abuse case, otherwise imprisonment for 6 months or fine. It may affect right to medical aid of a child. So, this is, you see, mandatory reporting. No one can hide or conceal the information regarding child sexual abuse. Mandatory reporting, otherwise consequences is whoever fails to inform this child sexual abuse, that person may be prosecuted. Now, legal aid under POCSO. Is there any legal aid provision regarding legal aid under this POCSO? So, we will try to understand. Section 40 of this act talks about victim to avail legal aid, and I have collected a data from the website which I have referred. Up to 31st May 2023, there were 758 fast track courts in India, including 412 exclusive POCSO court. E-POCSO courts are functional in 29 states and union territories across the country. So, you can see the efficacy of this act in that sense that in more than 29 states and union territories, about 412 POCSO courts are functional, which shows the political will of the government as well as the efficacy of this act. As I said, section 40 of this POCSO Act talks about legal act. According to section 40, a child against whom offence is committed, that child is entitled to get legal assistance. Now, come to another aspect of this POCSO Act. This act has also criminalized consensual relationship, where both the child is below 18 years, engaged in sexual activities with consent. So, this provision is in debate, where both the child is below 18 years and engaged in sexual activities. So, what would be the procedure? Whether they can also be covered under this act? So, this is even consensual act is also covered under this act. Now, come to this role of Supreme Court in protection of children from sexual abuse. I have covered, you just look at your screen, I have covered two important case laws. The first is Sakshi versus Union of India AIR 2021 and second case is Alok Srivastava versus Union of India AIR 2010 Supreme Court. Munna versus State of UP AIR 1982 sexual abuse children in Kanpur jail. I have already highlighted this case. Where in news, Badaयूं gang rape, teenagers were victim in the incident. CBI filed a closure report, but court directed to reinstigate the matter. And second important case which was reported, that is Muzaffarpur shelter case, Kathua rape case. These are few instances of child sexual abuse. So, now you see in this POCSO Act, there are certain rules in order to expedite the provision of this Act. This POCSO Act also talks about interim compensation. Interim compensation, as you see this, I have already highlighted. Rule 9 of this POCSO rules allows a special court to award interim compensation for childs in needs after FIR registration. So, you see rule 9 of this act, it allows, permits the special court to award interim compensation when, for what, for whose child who is in need of care. So, the moment FIR is lodged by the victim or by the relative of the victim under POCSO Act, soon after the registration of FIR, that victim, child victim is entitled to get interim compensation, and POCSO court may pass interim compensation to that child on the basis of medical report and FIR. Second important provision of this act which you need to understand, that is Child Welfare Committee may recommend immediate payment for essential need like food, clothes, transportation using fund from DSLSA. Payment must be made within a week of receiving CWC report. So, that child is entitled to get monetary benefit, child is entitled to get compensation within 1 week from the date of report of the CWC. So, you see this is all about your POCSO rules which are very helpful in providing justice to the children. Apart from this, you all might be knowing that two important case laws, with the help of two important judicial pronouncement, I would like to explain that case. The first case is, I have just explained this case in my previous lecture when I was talking about justice to the victim of crime, where a mother who had lost her 9-year-old boy was brutally killed in police lockup. Since deceased mother was a domestic servant, she was not in position to fight a case. She was poor. So, a non-governmental organization NGO Saheli, that organization NGO decided to fight her case, and a public interest litigation was filed in Supreme Court by stating entire facts that it is a case of custodial death. Police station head officer called the boy to join the investigation, and when 9-year-old boy went there, he was killed in the police lockup. And you see this, irony of the law, then when matter was brought into the notice of Supreme Court held that it is a clear cut case of custodial death, and Supreme Court did not accept the plea of sovereign function. You all might be knowing that in such type of incident where custodial violence or custodial death is reported, brought into the notice of Supreme Court, one common plea which is taken on behalf of government counsel before the Supreme Court is sovereign function. Sovereign function here means function which is exercised by the government to maintain public justice, to maintain law and order. So, it was pleaded on behalf of government counsel in the Supreme Court that police officers, they were performing their duties prescribed by the statute, and whatever they did, they were bound to perform their duties in accordance with Police Act, in accordance with the statute to maintain law and order. So, their act, their function should be considered as sovereign function, and they should be exempted from criminal liability. But government failed to convince the Supreme Court, and Supreme Court did not accept the plea of court and awarded. Supreme Court directed the state government concerned to provide compensation to the deceased mother. In this way, the point which I want to make it clear, that is how rights of a child has been protected by the Supreme Court. This is another important illustration. Mathura rape case which I have already highlighted. Another important case which is very common, which I have already explained in previous lecture, that is Nilavati Behra versus State of Odisha, where a 16-year-old boy was brutally killed in a police lockup, and in order to convert that killing into suicide, the concerned police officers, they had thrown out the body of deceased on the railway track nearby the police station, so that that killing can be converted into suicide. I have already, I think no need to discuss entire facts of this case. The point which I want to make you, that is how the rights of a child. In this case, what happened, you see, when matter was, since Nilavati Behra, she was poor, she was not in position to, so then she wrote a letter to a judge of Supreme Court, and her letter was accepted as a letter petition, and Supreme Court directed to conduct inquiry. All allegations were found true. On that basis, Supreme Court directed the state government to provide compensation to the mother of deceased, and she was awarded 1,50,000 compensation because she had lost her 16-year-old boy, and he was, the deceased was her sole child, only child, who could have managed financial assistance for her. So, Supreme Court considered that case as a custodial death and awarded compensation to the deceased mother. And second important thing which you need to remember, that is state was, even police officers who were involved in that incident were also held responsible for the wrongful act. So, this is all about your two important case laws which you all need to remember, and you all might be knowing that where in accordance with Article 15 Clause 3, Parliament has enacted special legislation for the betterment of children. The name of that act is Protection of Rights of Child Act, Juvenile Justice Act 2015. Juvenile Justice Care and Protection Act 2015, which I would like to highlight. You see, Juvenile Justice Act was enacted for the first time in the year of 1986. Juvenile Justice Act 1986 was enacted by the Parliament just to provide, just to protect the rights of certain rights of the juveniles, but that act was inadequate. That act could not fulfill the desire. So, Parliament again in the year of 2000 and again in the year of 2006, Juvenile Justice Care and Protection Act was enacted in the year of 2006. Ultimately, Juvenile Justice Act 1986 was repealed, new legislation was enacted. In 2015, again Parliament enacted special legislation for juveniles. Now at this time, Juvenile Justice Care and Protection Act 2015 was enacted. This act was enacted by Parliament in the light of recommendation made by Justice Burma Committee. Justice Burma Committee was set up, was constituted by the Government of India after Nirbhaya incident. You all might be knowing that Nirbhaya incident happened in the year of December 2012 in Delhi. So, after that Nirbhaya gang rape case, one culprit, one offender was juvenile who was below 18 years. So, who was also involved in that incident. So, Burma Committee recommended that as per the recommendation of Burma Committee, this act was enacted by Parliament in 2015. So, juveniles are entitled to get certain benefits under this act, which I would like to highlight. You need to remember two things: juvenile conflict with law and juvenile need in care and protection. Juvenile in conflict with law means, here juvenile is a person who is below 18 years. Juvenile in conflict with law means juvenile who has committed crime, who has breached the law, and that juvenile needs special care and protection so that he cannot become habitual criminal. So, this special legislation talks about certain safeguards provided to the juvenile under this act. What are those safeguards? For example, juveniles shall not be kept along with habitual offenders. There should be separate cell for the juveniles at each and every district. Every state shall establish separate juvenile district reformatory homes for juveniles, so that juveniles can be kept safely in that place where only juveniles should be kept. They should not be kept, they shall not be kept along with habitual offender. So, this act talks about district reformatory home. There should be separate reformatory homes for juveniles, shelter homes, reformatory homes. They are entitled to get special attention and special care, and it is duty of authorities to provide psychologist, psychiatrist, psychotherapy, medical assistance to those juveniles who are really in need of medical treatment. So, authority designated under the act, they are supposed to provide medical assistance to the juveniles. Authorities are also bound to provide legal assistance as well as medical assistance. So, juveniles the most significant provision of this Act is where a person who is above 16 and below 18, though that child is considered as juvenile child, but that juvenile who is above 16 years and below 18 years may be treated as an adult, considering the nature and consequences. If he was in position to understand the nature and consequences of his act at the time of doing the act, he shall be considered as an adult and he may be prosecuted, he may be deprived from the benefit of Juvenile Justice Care and Protection Act. So, you all need to understand all these things in, and the important thing is that Juvenile Justice Act, the background of this act is Sheela Barse case. Sheela Barse versus State of Maharashtra, AIR 1986 Supreme Court. As you all might be knowing that this is very popular case, Sheela Barse case. What happened in this case? Sheela Barse, she had filed a petition in Supreme Court by highlighting the plight of juveniles who were languishing in jail, different jail of this country. So, Sheela Barse, she filed a petition in Supreme Court by highlighting the plight of children. Till means at that time in 1986 there was no separate provision for juveniles. In the meantime, Supreme Court itself, Supreme Court Committee on Legal Aid, SCLAC, Supreme Court Legal Aid Committee, SCLAC, filed a petition in the Supreme Court. The name of case is SLAC versus Union of India. There is, I do not want to go into the technicality of that case, I do not want to discuss the facts of this case, it will take time. But the point which I want to make it clear at this point of time, that is, it is the Sheela Barse who had played important role, significant role behind this act. She has been very instrumental. Means if you will go through the fact of that case, you will find that the first Juvenile Justice Act 1986 was enacted, and that act was enacted in the background of that legislation. Sheela Barse case has been very instrumental, has played significant role. So, this is all about your judicial contribution, role of Supreme Court in protection of human rights of child. In addition to this, Immoral Trafficking Prevention Act, there is also a special statute which prohibits that trafficking of child is an offence, and whosoever is found guilty for trafficking of child may be punished under that act. So, immoral trafficking statute is there. Indian Penal Code, I have already highlighted that statute where the offence child abuse, child sexual abuse, that has been criminalized. Apart from this, you might be aware about one important word which I just want to mention on this slide in brief. Incest sexuality, I have not covered that. Incest sexuality, there is a case, there is a leading case on this by the Supreme Court has also intervened in this. Incest sexuality here means where children are abused, sexually abused by their own relatives. So, that act is known as incest sexuality, where a child who is a victim of his own father or mother victim. So, that crime is specifically known as incest sexuality. So, where relatives are involved in committing sexual offence against that child. So, where child is victimized by his or her own relatives. So, that is known as incest. So, many statistics, many research reveals that um, incest sexuality is also one sensitive issue in this country, where law needs to take care of this kind of act. And Wahid, there is a leading case on this. Due to shortage of time, I do not want to discuss this case. Now, let us understand this rights of child. There is also an important international instrument on the rights of child, that is known as CRC. If I mention this CRC on this screen, CRC 1989, Convention on Rights of Child 1989. So, you see, this is the first effort. I think in 1989, United Nations General Assembly made an attempt to recognize the rights of child by multilateral agreement, and the name of that agreement is Convention on Rights of Child 1989. According to this convention, a child is a person who is below 18 years. So, this convention CRC consider all the persons who are below 18 years shall be considered as a child, and they are entitled to get all the benefits children can get in their domestic laws. India too, India is also party to this CRC. So, we have adopted this CRC, and also you might be knowing that there is no uniformity regarding the definition of a child. In our legal system, Article 24 of the Indian Constitution gives definition of a child, that child is a person who is below 14 years. So, according to Article 24 of the Indian Constitution, a person who is below 14 years shall be considered as a child. On the other hand, CRC 1989 considers a person who is below 18 years as a child. So, there is no, you see, there is no uniformity regarding definition of a child, and now time has come to extend the age of child only for the educational benefit, so that we can provide education to our children. If this definition is amended by the parliament, by amending this provision, we can extend that in our legal system, we shall provide education free of cost to those poor children who are below 18 years. So, by doing so, we can enhance our, we can increase our literacy rate, as well as we can educate our children who are not in position to pay huge fee of private schools. So, this it needs to be amended. This means Article 24 needs to be amended in the light of CRC 1989. So, you see, I have covered each and every aspect of rights of the child, POCSO Act especially, and the most significant thing which I would like to discuss in this POCSO Act, in order to make this POCSO Act more effective, the nature of POCSO Act is cognizable. Nature of offence, I just want to mention this cognizable offence, and offence is non-bailable. You must understand this, non-bailable. So, child sexual abuse under this POCSO Act is cognizable offence and non-bailable. The moment FIR is lodged against the wrongdoer under POCSO Act, at that very moment it gives liberty to the police to arrest the wrongdoer without order of the court. So, in order to make POCSO Act more effective, this Act has made that offence cognizable and non-bailable. You see, the moment complaint or FIR is registered under POCSO Act, that person is deprived from getting benefit of bail from the court. Bail application can be rejected unless the charge sheet is produced before the court, unless the final report is submitted before the court. That wrongdoer will have to remain in jail. So, this is the effect of non-bailable offence. So, I have highlighted these two important things in POCSO Act. You must understand that this POCSO Act is very sensitive, and considering the plight of Indian children and their social status, this Act makes this offence more severe, more heinous, in that sense that if FIR regarding POCSO is registered, it would be a cognizable offence. At that very moment, it gives liberty to the police to arrest the wrongdoer. To grant bail or to reject the bail, it is the sole discretion of the court in POCSO Act, because the nature of offence is non-bailable. So, you see, after insertion of these two things, after the inclusion of these two things, this Act has become more effective. In order to make this Act more effective, the nature of offence has been declared as cognizable and non-bailable. So, you must remember all these things. I have covered each and every aspect of right from Universal Declaration of Human Rights, constitutional provision regarding rights of child, safeguards provided in the Constitution, POCSO Act and its efficacy, and safeguards provided under this Act, legal aid provided in this POCSO Act, role of Supreme Court in protection of rights of child. I have covered each and every aspect, and assuming that you all have understood the things which I have discussed in this lecture, and I do hope that you all have understood the things. So, with this I would like to conclude this lecture. Thank you all.
I am A.K. Sharma and I teach sociology at IIT Kanpur. I am going to address the question, what is the relevance of statistics in sociology? In India, there is some confusion about role of statistics in sociology, and most of the students of sociology suffer from what I call phobia of statistics. But actually, if you look at history of sociology or the kind of works that are being done in sociology, which are published in prestigious academic journals, you find that there is a lot of use of statistical methods, and not simple methods, very advanced methods. All of you know, as students of sociology, you know that one of the founding fathers of sociology, Comte, or another founding father, Emile Durkheim, they said that sociology is one subject which differs from other subjects in the questions that they try to answer, but they use the same method, the method of science. And that in sociology, those who believe in this kind of approach, they are called positivists. Emile Durkheim called them positivists. They believe that social issues must be studied by using observations, experiments and other modes of collection of data. Now, statistics can help sociologists in three ways. Because if sociology is about social facts or patterns, not individuals, patterns of thinking, patterns of feeling, patterns of acting, behaving, and they can be measured, they can be quantified, and that explanation of one social fact can be given only in terms of other facts. We need statistics, because statistics can measure these facts, statistics can describe these facts. So, one branch of statistics, we can call it descriptive statistics, can help us in summarizing data, in measuring facts, like you are all familiar with simple statistical things like mean, mode, median, or methods of dispersion, standard deviation, range, variance. These are descriptive measures. They can also be used to measure skewness or symmetry or asymmetry in the data. Other types of statistical methods, which are called inferential statistics, are used to test hypotheses. We know that any science, including sociology, if we follow that positivistic tradition, is about testing hypotheses using scientific methods. And for testing hypotheses, like for comparative purposes, comparing means of two samples or comparing variances of two samples or comparing correlation coefficients or regression coefficients, we need inferential statistics. And if you are familiar with some of them, t-test, z-test, chi-square test, f-test, these are the tests which come under inferential statistics. We use statistics for drawing inferences about two or more samples. And thirdly, statistics can also be used for posing new questions. I remember that a few months ago, I read an article in Population and Development Review in which the authors Cole and Gramajo, they tried to explain homicide rates and variations in homicide rates across countries in the entire world. And they found, based on statistical analysis, logistic regression and all, they found that one factor which explains variations in homicide rates in the world is female education. Not culture, not governance so much, not even male education, but female education. Now, if facts are showing this, so you have a new sociological question, why is it that rise in female education leads to higher homicide rates? And Cole and Gramajo then gave certain hypotheses. You may not agree with those hypotheses, you may conduct this study on your own or test these hypotheses given by Cole and Gramajo using statistical methods. But the point I am making, that in addition to describing data, drawing inferences, statistical methods can also be used for raising new questions in sociology. And of course, you are all familiar that whenever the issue of prediction comes, predicting population of India, predicting urbanization, predicting per capita income of India 20 years from now, 50 years from now, there also statistical methods are of great help. And finally, statistical methods have been used in monitoring and evaluation of development policies run by various governments and NGOs. Thank you very much.